just about 2 minutes before, but I think we can commence. Just with any housekeeping matters that we need to deal with.
None from the applicant.
Thank you. Dr. Zay?
Now we can proceed, thank you.
Nothing?
Nothing.
Okay, very well. In which case, then let's continue. Each party has 1 hour to make their closing presentation. Mr. M.
Thank you, Mr. President, and esteemed members of the committee. First, let me begin by thanking the committee again for its attention to the parties' arguments yesterday and for the excellent questions raised at the end of the day, as well as your helpful direction in terms of the things that would be most helpful to you during our presentation today. I think everyone's been distributed now the PowerPoint that will accompany our hour-long presentation. If we can move to the 3 main topics that we'll be covering: the legal standard of annulment, then I'll, again, with your leave, Mr. President, pass the floor to Mr. Pekash and Mr. Pustai that will address the tribunal failed to state reasons on which its conclusions on quantum was based. And finally, we'll conclude with the tribunal manifestly exceeded its powers by refusing to exercise jurisdiction over certain claims. Let me first begin then with the legal standard of annulment and to the excellent question raised by arbitrator Anneker yesterday. That question related to the standard for contradictory reasons that may lead a committee to annul an award. And as we understood the question, it was to try to develop a little bit more the necessary elements of contradictory reasons as a ground that may lead to annulment, and in particular, distinguishing such reasoning from contradictory assessment of evidence. You also asked that we do so by reference to the jurisprudence, which we again reviewed last night quite thoroughly. And I think we have a very clear answer to that question. Let me preface it by saying I'll have 4 points, the first 3 of which probably won't directly address the question, but the 4th will. The first point I want to make is that this analysis only pertains to contradictory reasons. It does not pertain to the utter absence of any analysis or mention of evidence whatsoever, which we talked about yesterday in the context of the evidence concerning actual contemporary transactions and how the tribunal did not even mention those particular transactions at all. That falls within a different rubric within the failure to state reasons under 52(1)(e). The tribunal will recall there are 4 different bases on which to annul an award under that provision. The ignoring of evidence entirely is a separate category from the contradictory reasons. So this answer will only pertain to the contradictory reasons. The second point is, having reviewed the jurisprudence again last night, every single annulment committee that has considered the failure to state reasons has concluded that contradictory reasons are itself a basis for annulment. The third point, and I think this starts to address your question now more directly, is that most annulment committees effectively require a 2-part test. First, that the tribunal's reasons cancel each other out. That's effectively the definition that most of the annulment committees have used when trying to define contradictory reasons, that they're not reconcilable. And the second is that those reasons were necessary for the decision. And now I come to the 4th point, which I think really addresses the heart of your question, which is, how are contradictory reasons that are the basis for annulment under 52(1)(e) different from contradictory assessment of evidence? And although, based on our reading, albeit a quick refresher last night of the jurisprudence, doesn't reveal committees that talk about this issue in detail, what you glean from the jurisprudence when you review the holdings carefully and you try to reconcile them, as well as looking at some of the academic literature, and I'll point to one piece in particular, is that contradictory reasons for purposes of 52(1)(e) relates to the methodology that a tribunal uses, whereas the latter point, that is the assessment of evidence that is not subject to annulment, relates to whether the evidence is, for example, credible, or what the evidence actually says. Now, let me point you to, and if we need to put this on the record, I'm happy to do so. I was loath to put up slides of legal authorities that are not in the record. But, for example, Frederick Sojourns from, I believe it's Tulane in the United States, professor of international arbitration, stated, one form in which an award can fail to state reasons is that it is self-contradictory. Self-contradiction is annulment is annullable rather than without consequence if it goes to the basis of a decision of an award and arises as between the decision of the tribunal and its legal analysis. And here's the key language. The typical manner in which such self-contradiction can arise is methodological. So let me give you an example in the context of this case about how these principles apply.
Mr. President, I'm sorry to interrupt my colleague, but I would be grateful if he could provide a reference.
Sure,
to the record
very happy to do so.
He's citing.
Very fair. So this is Frederick Sorgens, S-O-U-R-G-E-N-S, article Evidence and Annulment in a journal Evidence in International Investment Arbitration, Oxford University Press, 2018, pages 280 to 282.
Yeah, and exhibit number?
As I said previously, this is not on the record. It's in response to one of the tribunal's questions, and we'd be happy to put it on the record.
Mr. President, I think that this is unfair introduction of new evidence, and I would ask you to strike this reference from the record. Thank you.
This legal authority
That's right.
that they are trying to use to persuade the committee, and I hope to give you a copy of the.
Absolutely.
Yeah, have a look if you want to respond to it later.
Okay, so we wanted to introduce new exhibits in response.
Sure.
Thank you.
So let me give you an example of how these principles apply in the context of an arbitration or indeed this case. If the tribunal wrongly decides that a piece of evidence is credible or not credible, that clearly is not annullable, even if it's stated in some kind of contradictory terms. Similarly, if a tribunal were to conclude that a document states A when in fact the document states B, that too would simply be an error that would not be subject to annulment under Article 52(1)(e). But what is annullable is if the tribunal uses contradictory methodology regarding that evidence. And so you can almost view this as sequentially. The tribunal first assesses the evidence, that's within the tribunal and only the tribunal's domain. But then if the tribunal applies contradictory methodology and how it applies those factual determinations, that's when 52(1)(e) is triggered. So now let me give you the actual example that applies in the case here. If the tribunal got wrong whether a document was really pre or post valuation date evidence, that would not be subject to annulment under Article 52(1)(e). But if it says in its methodology that post-valuation date data is not relevant, and then bases the valuation on post-valuation date data, it is contradictory as a methodological point, and therefore requires annulment under Article 52(a)(e). Now, you had asked for reference to the jurisprudence. I think one good example of this is the Tidewater versus Venezuela case, which we discussed in our papers. It is on the record. And there the ad hoc committee annulled the part of the underlying award quantifying compensation for the expropriation of the claimant's businesses on the ground that it was based on contradictory reasons. And having adopted a discounted cash flow methodology, the tribunal had identified with clarity and force 6 elements as the basis of an informed estimation of market value, including the scope of the relevant business and the high country risk factor of 14.75%. But despite that, instead of basing its compensation quantum conclusion on evidence in accordance with the risk factor, the tribunal then adopted a figure several times larger, which was taken from evidence based on a country risk premium of 1.5, which the tribunal had already rejected as unreasonable. And the committee therefore annulled this quantum decision because the methodology used by the tribunal was contradictory. Now let me say again, this has nothing to do with the complete ignoring of relevant evidence, which is a separate ground under Article 52(1)(e) for failure to state reasons. But as to your question specifically about the difference between contradictory reasons when assessing evidence versus contradictory reasons that can be the basis of annulment, I think the fact that it's the methodology rather than the tribunal's exercising of its authority to weigh the credibility of evidence and to determine what the evidence says is the key difference. So I hope that answers the question. With that, Mr. President, I would ask for your leave to turn the floor over to Mr. Pekash and Mr. Pustai to address the remainder of our presentation.
Thank you. Good morning, members of the tribunal. We will start with, we will follow generally the same order of presentation as we did yesterday. And we will start with the principles and the very helpful question we got about where exactly these principles are formulated. We did identify 6 principles which we submit guided the tribunal's decision on the parts of quantum which is subject to review. These principles were not announced, as the tribunal obviously knows, in one place as principle 1, 2, 3, 4, 6, but we derived them mainly from Article 693 of the award. So what we did on these slides is that we always show you how we formulated the principle, and we admit this is our formulation of the principle. Then we show you the text of the award, which leads us to conclude that this is what the principle, that the tribunal adopted the principle. And then what we have on the bottom of the slide is references to the claimant's submissions and respondents' submissions and also their expert submissions where this principle was discussed. So the first principle, that the valuation should be based on actual comparable transactions, is the primary, most relevant evidence, was very uncontroversial in the entire arbitration. Actually, both parties agreed. And I believe we heard that coming from Serbia yesterday as well, that actual comparable transactions are the highest level of evidence. Principle number 2, asking prices have the lowest evidentiary value, and the valuation should not rely on asking prices with no corresponding information about dates and sources of these prices. It also comes from Article 693 of the award, where the tribunal announces the principle by referring to what Mr. Grzesik said, we would say with approval of the quoted parts. Again, this is a principle which was not disputed as between the parties and the experts. The references are on the bottom of the page. Principle 3, the valuation should only rely on evidence from comparable areas that is embedded in any comparables analysis. Again, that part of it is not controversial. What was controversial was the factual issue whether the Batajnica area is comparable or not. Again, in the bottom you have references to the submissions. And we highlighted the part of 693 which explains that this is clearly something which the tribunal followed when it excluded the Batajnica area. Principle number 4, the valuation should only rely on evidence, information available on or before the evaluation date. So this is a principle which is very clearly articulated by the tribunal, again in 693. Both here, actually, the parties were not in complete agreement with this because both parties referred in their submissions to evidence post-dating the valuation dates, but obviously the tribunal was absolutely right to retain that principle. We were also asked to elaborate on how exactly we understand the rule. So we submit that the rule is relates to information and the date when the information became available. This is because the principle is linked to the determination of fair market value. The universally accepted definition of fair market value requires that both a willing buyer and a willing seller act knowledgeably, that is based on information available as of the evaluation date. The authority we cite here for the proposition is Illich's first report. Again, the definition was not really subject to any disagreement between the parties. And so our answer to the question is that the relevant question is whether the information used in valuation was available as of the valuation date. So there may be information which predates the valuation date but was not known at the valuation date. That information would not come within the ambit of information predating the valuation date. only information which is available as of the valuation date can be said to be predating the valuation date and therefore to be taken into account for the purposes of valuation based on the principle that post-valuation date information should not be used. Principle 5, a discount is justified where evidence used in the valuation relates to comparable land with better access to infrastructure. We derive that from the tribunal's reasoning in paragraph 697 of the award, and it stems mainly from the second highlighted sentence where the tribunal stated, to the tribunal applying a discount appears reasonable as any buyer would incur costs and spend time in developing BD Agro's land and would factor the development costs and time into the price offered. This was discussed mainly in the post-hearing briefs of both parties because this entire idea of a discount for infrastructure was introduced by Mrs. Or let's say emphasized by Mrs. Illich mainly at the hearing. Principle number 6, smaller land plots are more valuable per square meter than comparable larger land plots. This is also something we derive from the tribunal's reasoning in Article 697. And again, it was discussed in Illich's second expert report and then in our rejoinder on jurisdiction and the first post-hearing brief. I believe that this is also uncontroversial. Having answered another 2 of the tribunal's questions, I will now turn into our submissions on the Dobanovci transactions. We got a question to explain how that evidence was relied on, and we thought it would be good here to introduce also the history of how that evidence was introduced, because it was introduced relatively late, which explains why the parties relied on it the way they did. So the evidence was not available, or Dr. Hearn was not aware of it when he filed his first report, which was filed with the memorial. It was not mentioned in the counter memorial. Dr. Hearn was also not aware of that in his second report filed with the reply, nor was Mr. Grzesik, another expert of claimants. The documents were introduced only in the first expert report of Mrs. Daniela Illich. It's the first report, but it was filed with the rejoinder. The fact that this evidence was, and many other pieces of evidence were introduced only at the rejoinder stage, then led to a procedural decision which allowed claimants to address some, but not all, aspects of quantum with their following sort of third submission. The submission was still called rejoinder on jurisdiction because that's how it was planned originally in PO1, but we were allowed to also address quantum. Dr. Hearn filed his third expert report in that connection, and in that report he stressed that the 2 transactions confirm his valuation. The 2 transactions became central at the hearing when claimants, Mr. Grzesik and Dr. Hearn, all relied on them in their presentations. I will show you all of these references further down. And then in claimant's post-hearing brief, there is a significant subpart of the post-hearing brief which deals only with that decision and to these 2 transactions and refers to them as one of the bases for claimant's valuation at 30 euros per square meter. So here in the following slides are the excerpts of what I have just announced to you. So this is how Mrs. Illich identified the 2 transactions in her first report. This is one of the 2 references that Dr. Hearn had to the 2 transactions in his third report. And here is the hearing. So first, during the opening statement, claimants argued that Mrs. Illich should not have disregarded 2 transactions, referring to another part of Dr. Hearn's third report where he addresses the 2 transactions. We explained during the opening statement that there was no reason to disregard the transactions because, and this is the second highlight, the transactions are clear market evidence and we haven't seen any compelling reason why this should be disregarded as Mrs. Illich does. Then came the time of expert testimony. So on 19 July 2021, the first one to appear was Mr. Grzesik. who expressly stressed in his presentation the importance and relevance of the two transactions. This is his slide. And then the presentation he had actually underlined that the two transactions are the highest type of evidence a valuer could hope for, and that the closer of the two transactions, the one at the 28.4 euros price, was highly relevant because the land is adjacent to the BD Agro land. Then we had cross-examination of Dr. Ilic. In that connection, I would like to correct one thing which was said here yesterday. It was stated that Mrs. Ilic maintained her view that the transactions are in a residential area. That, members of the tribunal, simply is not true. This is a transcript from her cross-examination. It is true that her first answer was, yes, I maintain they are in a residential area. But then I asked Dr. Ilic, showing her a map, with respect to point C. Can you see any residential buildings to the north? No. Can you see any residential buildings to the west? No. What can you see to the south? There's the farm. To the east, there are some big roofs, some halls, which definitely are not residential buildings. So she confirmed that there are no residential buildings to neither of the four sites of point C. We wanted actually to play you a video of that cross-examination. Unfortunately, it is not possible to play sound in this room. We had the idea too late. But what you do have on is in the soft version of the presentations we sent, there is a link to the video, which is available on YouTube as the entire hearing is. So you can see how the cross-examination went. What you can see on this picture also is that what we were putting to Dr. Ilic is the same photograph Serbia was showing yesterday. Point C is the red dot to the left. The big roofs we see south of it is the farm. Then there are like smaller roof to the east and she admitted that these are not residential buildings. And then we can see just fields to the north and to the west. And we know that further to the west that there is zone A, the farm is here, zone B, or in vicinity. I will show you another picture which shows the location of point C compared to the zones. Mrs. Ilic also admitted that the farm, and I quote, has infrastructure, has everything. And she admitted that the same asphalt road, which is next to point C, then goes down to the farm and extends beyond the farm and goes partially through the construction land zones B and C. So this is the picture. Her cross-examination was followed by a presentation by Dr. Hearn, who stressed in his presentation the importance and relevance of the two transactions. And you know, this is one slide out of only 30 that the expert had, and you will see there was another one. So it was like 7.5% approximately of the slides that he had were on the two comparable transactions. So what you can see here, the blue dot with euro 28.4 is the more comparable of the two comparable transactions. The farm is right south to it. And then you can see zone A further to the left across the one part of the field, then zone B adjacent to the farm, and zone C further down. The yellow line coming approximately from the north to the south is a major road, Sremska Gazela, which was to be built there and provide access to all three zones. So in his presentation, Dr. Hearn stressed the importance and relevance of the two transactions. You just have his words here. He especially said that there are two particular transactions that Mrs. Ilic identified for very similar land to BD Agro's land. He explained he did not have an opportunity to address them earlier. And then he said, so as Mr. Grzesik said yesterday, actually there are very good reasons why this land, the ABC land, actually has the potential to be even more valuable than this 20.4 28.4 price due to the future construction of the Sremska Gazela road. And he, and that's crucial, also explained that the two transactions fully support his valuation of the construction land. So he did rely on these transactions. Yesterday we somehow heard that we relied on the transactions just to criticize Dr. Ilic, but that's absolutely not true. When we saw the transactions and when our experts saw the transactions, they fully espoused them and started to rely on them. And that was made absolutely clear in the post-hearing brief, where we stated that the Dobanovci transactions are one of the two major comparables which support our valuation at 30 euros per square meter. And there is this part in paragraph 308 and following, which addresses only this. We also showed in the post-hearing brief that Mrs. Ilic admitted upon cross-examination that her reasons for excluding the two transactions were factually incorrect because Point C is not in a residential area. The transactions are right next to the land on which Vidiagros farm is located, and that the land plot next to Vidiagros farm, Point C, was connected to a small municipal road which then extends to the farm and to zones B and C. So what is our conclusion on the two transactions? First, the tribunal simply ignored them completely. There's not a word about them in the award. Nothing in the award shows that the tribunal implicitly rejected the two transactions. The fact that they agreed with Mrs. Ilic's number does not mean that they agreed with all of her reasons. Actually, sometimes they disagree with her. And even if we accepted that...
Just pausing there, Mr. Becker. So you still talk about the two Dobanovci transactions when you are actually illustrating to us only one transaction that seems to be relevant. So which is which?
We accept that one of them is the most relevant. This is the closer one, and 28.4. The other one is, we would submit still relevant, that Mrs. Ilic's comparables, but we accept that there is a hierarchy of relevance, if I may put it that way, as between the two. So if we accepted that it is enough for a tribunal to say, oh, we agree with Mrs. Ilic or Mr. Cowan, and that is sufficient then to imply that the tribunal agrees with everything they said, we would end up with the kind of award that Mr. Enway was showing you yesterday. The entire submission of quantum, decision on quantum would be one paragraph. We agree with the respondent. And the number is what the respondent said. And clearly, even the tribunal did not apply that standard, because this is why the tribunal was distinguishing specific transactions. So they did speak about Batajnica. They did speak about the first Confinex report. Why would they have done it if they themselves thought that it is sufficient to refer to Mrs. Ilic and, we have done our job? So this is not the standard of reasoning which is required under the ICSID convention. We say, especially when the parties put emphasis on some piece of evidence, like the two transactions, and especially the one related to point C. If a piece of evidence is discussed so thoroughly, it requires, I would say, at least one sentence by the tribunal to say, we have read it and we disagree with it for reasons A, B, and C. And then it would not be annulable, obviously, the reasons given. If the reasons are internally coherent, then it's not an annulable error, but something has to be said by the tribunal. Serbia submitted yesterday that this is an issue of the tribunal's assessment of facts. It is not. It would have been if the tribunal had said something. Then, yes, had they said this is not a credible piece of evidence. If it had provided internally coherent reasoning with respect to their assessment of the evidence, it would have been an issue of assessment of facts, and then we could be discussing what the standard of annulment is with respect to that. Complete silence is something different. Now, very briefly, on the other things which we relied on, we told the tribunal yesterday that the committee yesterday that the tribunal also ignored the second Confinex valuation. I will really skip through these slides because in the interest of time, but this is how we relied on it in the memorial. Actually, Mr. Cowen initially relied on the second Confinex valuation to value BD Agro's assets as well. And then, again, at the hearing, we put significant emphasis on it. This is a slide that we were showing the tribunal. We were estimating the value of capital specifically by reference to the first Confinex valuation. We stressed its relevance, and we even included it in our conclusion at the hearing. We were proposing, several numbers. We told the tribunal, okay, if you stick with our numbers, the BD Agro equity value is what you see on the top. Then if you stick with Mr. Mergut's numbers, it's going to be 71 million, first Confinex, second Confinex, Mr. Cowen. So that was a central piece of evidence, the first Confinex report. And again, there's not a word about it in the award for the purposes of the valuation of BD Agro's land. So yesterday, the only thing Serbia had to say about second Confinex is that it was not relied on and it was not a key document. And this is just plainly incorrect. I have just shown you how we relied on this document in our submission before the tribunal. Then the third instance of complete ignorance are the Pazova transactions. So it's the same exercise. First, I'll show you the slides where they were relied on here by Dr. Hearn in his first report. Then on the following slide, we see how he relied on them in his third report. When so Mrs. Illich criticized the transactions, he responded to the criticism. We also responded to the criticism in our rejoinder on jurisdiction, which addressed some aspects of quantum. Mr. Grzesik testified at the hearing that the Pazova transactions enter into Dr. Hearn's valuation. So he confirmed that, yes, Dr. Hearn uses them. Dr. Hearn himself confirmed at the hearing that the Pazova transactions are relevant evidence on which he based his valuation of the construction land. Again, they were included in his presentation. And the tribunal does not say a word about the Pazova transactions at all. And Serbia's only defense is, again, that Dr. Hearn did not rely on the Pazova transactions. We submit this just cannot be true. You have seen the evidence and you can assess it yourselves. So now let me turn to Batajnica. And here I will be just commenting on what was said yesterday by Serbia. So the first issue with Batajnica is that the tribunal stated that land located in the Batajnica area was not comparable to the construction land, but then accepted Serbia's reliance on an asking price for land in the same area. Nothing in the text of the award suggests that the tribunal's rejection of the land in Batajnica as a suitable comparator related solely to the specific land plots identified by Dr. Hearn, as opposed to all land plots in the Batajnica area. Really, if I look at the text of the award, it refers to the Batajnica land. There's no distinction here between the specific land plots and any other land plots. And Serbia's arguments to the contrary are based only on Serbia's own interpretation of the evidence filed in the arbitration, rather than on the text of the award. And this is not an accurate argument, because the tribunal here is a judge of the award and the reasoning provided in the award. The award must be self-explanatory. It's not that we need to look into the evidence to try to figure out what the tribunal may have had in mind. The tribunal also rejected Dr. Hearn's reliance on the Batajnica transactions because they allegedly post-dated the valuation date, but then accepted Serbia's reliance on asking prices with unknown dates. And we submit Serbia simply cannot explain the contradiction in the tribunal's approach. Number one is a factual point. Mrs. Illich never stated that her first two asking prices, which are the asking prices with missing month and date, predate the valuation date. And you saw some excerpts from her reports, which Serbia showed you yesterday. Please review them. None of them says, and these two transactions, I do not know the date, but I know that the date predates the valuation date. They simply don't. The contradiction, again, does not concern the tribunal's assessment of evidence, because the tribunal did not state that it considers that the two asking prices predate the valuation date. Had the tribunal stated so, it would have been an error by the tribunal, not subject to annulment. But the tribunal does not comment on the date of these transactions. It just refers to the document. The contradiction arose only in the award. And so Serbia cannot seriously state that Mr. Rand now cannot point to it because, and I quote, claimants failed to raise this argument during arbitration. The last aspect of the Batajnica transactions is that the tribunal rejected them because they are allegedly different from property valuations based on international standards, but then accepted Serbia's reliance on asking prices, which are also different from property valuations based on international standards. Here, Serbia does not seem to dispute that neither Mrs. Ilic's asking prices nor the Batajnica transactions are evidence of actual transactions. And we submit the only logical conclusion is that, therefore, the tribunal's rejection of Dr. Hand's reliance on the Batajnica transactions due to them not being evidence of actual transactions is contradicted by the tribunal's acceptance of Mrs. Ilic's 5 asking prices, which also are not evidence of actual transactions. Now, the first Confinex valuation. The tribunal refused Dr. Hearn's reliance because it was not based on comparable transactions, but then accepted Serbia's valuation, which was based solely on 5 asking prices and no comparable transactions at all. Serbia's only argument in the presentation we saw yesterday is that the first Confinex valuation was rejected because it, and I quote, does not refer to evidence of comparable transactions. So Serbia seems to be making a difference between evidence of comparable transactions and comparable transactions as such. In our opinion, this is a distinction without a difference, because Mrs. Ilic's asking prices also are not evidence of comparable transactions. I'm addressing this argument presented by Serbia yesterday to the best of my understanding of this argument, but really, in our opinion, they are just making a distinction without a difference. What matters is that asking prices are neither comparable transactions nor evidence of comparable transactions. They are not different from the asking prices in the first Confinex valuation. Also, sorry, from the data in the first Confinex valuation. The tribunal provided contradictory, insufficient, and inadequate reasoning for its acceptance of a 30% discount to the value of the construction land. Here, we believe that Serbia somewhat mischaracterizes the nature of the discounts that Mrs. Ilic applied and which may be generally applicable in an analysis of comparable transactions. So first, there is a 10% discount which Mrs. Ilic applied for the willingness to negotiate. Such a discount, by definition, only applies if the comparator is an asking price. There is no need for such a discount if the comparator is an actual transaction, because then it's already negotiated price, no need to discount it for willingness to negotiate. What comes second is a discount for differences between the valued land and the comparable transactions or asking prices or whatever the comparator is. That discount depends on the differences because it accounts for the differences. So no discount is needed if the differences are none or very small, and the discount increases with the differences. The bigger the differences, the bigger the discount. So what we derive from this is that one cannot just say, because Mrs. Ilic's prices required a discount, being asking prices, etc., any price would also require the same discount. And we submit that, for example, no discount is needed for the Dobanowski transaction at 28.4 euros per square meter because it's just the land next to the farm. So with that, that was just a methodological point about how the discounts should work. We submit that the tribunal's reasoning on the discount and its magnitude is insufficient and contradictory. The tribunal recalled that Mrs. Illich proposed a 30% discount to account for the size of BD Agro's land and other factors, in plural, such as the existence of infrastructure and access road. That's what the tribunal put in Article 695. Then the tribunal in Article 697, or paragraph, sorry, the tribunal disagreed with any discount based on the size of the construction land. It maintained a discount only for infrastructure and access to a road. And yet, the tribunal retained, without any explanation, the 30% discount which was originally proposed to account for all differences, including the difference in size, which the tribunal expressly said does not warrant any discount. And we said this is contradictory. If the tribunal cites with approval to the fact that a 30% discount is needed for A, B, C, and D, and then the tribunal says, but actually I think no discount is needed for A, how come that the magnitude of the discount is still 30%? And here, Serbia admits that the tribunal's entire reasoning related to the magnitude of the discount is only one sentence. This is a slide which Serbia put to you yesterday. And Serbia seems to say, oh, this was fine because the claimants, did not put an alternative figure of the discount. That is incorrect. We argued no discount, and no discount equals a zero discount. The tribunal cannot just say that, oh, because you said zero discount, I don't need to justify why it is 30. What if we had argued a 1% discount? Would then Serbia agree that the tribunal must explain why it's 30 and not 1? Probably yes, according to what we heard yesterday. So why not the same level of requirement of justification with respect to 30 as opposed to none? There's no logical explanation for it. And this is exactly, and here I repeat a slide I presented to you already yesterday, this is exactly what the ad hoc committee in Perenco versus Ecuador warned against. It stated that tribunals cannot just adopt a value as opposed to any other value without any explanation. And if we go back, we agree that the only explanation, actually the parties agree that the only explanation as to the magnitude of the discount is this one sentence, which is quite hard to understand, but in any event, this is insufficient. An issue which wipes out, on the tribunal's valuation, $18 million US, more than the size of what was awarded to Mr. Rand, cannot be justified by not even 2 lines. And that, members of the tribunal, concludes my submissions on the valuation of the construction line. With your permission, I will pass the floor to Mr. Pustai.
Good morning, members of the committee. Good morning, members of the committee. Same as yesterday, I addressed the remaining 2 points on the lag of reasoning related to the quantum, so failure to state any reasons for the remaining assets other than construction land, and the contradictory and insufficient reasoning with respect to the valuation of BD Agro's liabilities. Let me skip ahead a bit. So this is the table that you've seen quite a lot yesterday. This is the only explanation, this one footnote that the tribunal provided for these 6 categories of assets. What you heard from Serbia yesterday is that there is actually an additional reason for why the tribunal had to adopt Mr. Cohen's valuation. And what Serbia told you is that this is because the tribunal rejected the DCF method, which was used by Dr. Harn, and as a result, it was left with asset-based approach used by Mr. Cohen. So there are 2 issues with this argument. First, this argument is nowhere in the awards to be found, and actually Serbia itself raised it for the first time in its rejoinder on annulment. And more importantly, this argument is clearly incorrect, because as I told you already yesterday, while it is true that Dr. Harn used a DCF to value one part of the assets, farm assets, assets used to run the farm. He valued the same assets also using the asset-based approach. And you can see reference to both his report and his presentation at the hearing. And in addition, for another part of the assets that were not used to run the farm, and this includes, for example, the castle and land in Novi Bečej, he did not use DCF at all. He only used the asset-based approach. So we respectfully submit that Serbia's argument has no merit. The fact that the tribunal refused DCF analysis cannot be a reason for rejecting Mr. Hearn's valuation, because Mr. Hearn also used asset-based approach. Now, with respect to specifically Novi Bečej and the current assets, as we explained yesterday, there is no explanation in the award as to which assets fall into these categories and how the tribunal arrived to their value. Serbia told you yesterday this is not the case. This is clear from the award and Mr. Kavan's reports. But I will just note that Serbia is not able to point to any specific part of either the award or Mr. Kavan's report which would show that. So we will hear that from them today. Again, just ask them. Please point me to where the award explains what assets are included in Novi Bečej. Please ask them to point you to where the award explains how the tribunal arrived to the value assigned to the Novi Bečej. Now moving to the second topic, and that's the liabilities. So first issue, again, as we discussed yesterday, the tribunal first refused to rely on evidence or information post-dating the valuation date, but then relied on such evidence to calculate BDA gross liabilities. So first issue how this, or first reason why this enters the valuation is that tribunal accepted higher claim for interest related to the Banca Intesa claim or the BDA gross debt to Banca Intesa. And as you can see on this slide, it did so solely based on the documents and information post-dating the valuation date. This slide actually confirms that BDA gross financial statements prepared as of December 2015, so even that's 2 months after the valuation date, even those financial statements did not include this claim. And there is a reason for that. The reason is that as of the valuation date, Banca Intesa was not making that increased claim. That claim was only made in 2016 after Banca Intesa assigned its claim to another company, and then the company increased the claim. And you can see reference to specific documents actually in Mr. Kavan's report. Another issue with respect to the valuation date, as I said yesterday, tribunal relies on 2 documents to assign value to liabilities, 2015 financial statements and the second Confinex valuation. But both these documents actually rely on financial information as of the end of the year, as of 31st December 2015. And that information clearly postdates the valuation date. So by relying on these documents, the tribunal clearly contradicted its conclusion that the information postdating the valuation date should not be used in the evaluation. That brings me to another point, total estimated liabilities. As I explained yesterday, despite the name, this is just one line in BDA gross liabilities. And as I explained, issue here is that the tribunal stated that this one line item should be calculated without deferred tax liabilities, but then actually adopted a number which include deferred tax liabilities, and by doing that actually double counted capital gains tax, because those deferred tax liabilities actually represent deferred capital tax. Serbia addressed this point yesterday, but did not address any of these 2 issues. What they told you on this slide, and you can see it here, is that yes, tribunal repeatedly stated that this item should be calculated without deferred tax liabilities. Well, we agree, but that's the exact issue that we are raising. The tribunal repeatedly stated this, but then adopted a value that does not come from this approach, that contradicts this conclusion. Moving to the liabilities related to court proceedings, and again, the contradictory reasoning of the tribunal on this point. As I explained yesterday, tribunal's conclusion, these liabilities should be calculated based on financial statements and the Confinex, but then tribunal adopts the number that does not come from either of these 2 documents. So again, what is Serbia's reaction? Well, the tribunal did not allegedly rely on these documents for a specific number. It only relied on these documents to conclude that yes, this line item should be included in BDA gross liabilities. Well, again, there are two issues with this. First, there is nothing in the award that was stated. And more importantly, if that was the case, then there is no support whatsoever and no reasoning whatsoever for the specific number assigned to this line item in the award. Contradictory reasoning and ignorance of evidence with respect to the redundancy payments. Again, something I addressed yesterday. Tribunal concluded that the redundancy payments as a line item should be included because of Annex 1 of the privatization agreement, which, however, the tribunal concluded was not applicable as of the valuation date. So again, what Serbia tells you, well, this is allegedly not the case. And again, this is something that Serbia argues, not that the tribunal explains. This is allegedly not the case. The real reason was that the claimants did not prove that the redundancy payments were voluntarily. But members of the committee, this is not the point. The point is, was there a line item in BDA gross liabilities as of the evaluation date corresponding to redundancy payments? So in other words, was there a redundancy plan or program in place as of the evaluation date? And the answer is no. In 2015, in March, BDA Group prepared a reorganization plan, and more importantly, this reorganization plan was confirmed and accepted by Serbian courts, and it does not include any redundancy program. And this is for a reason. BDA Group adopted a redundancy program only after the expropriation, so only after Serbia took the company back, they adopted or put in place a redundancy program that was, by the way, specifically aimed only at state-owned companies. So BDA Group actually could not adopt that redundancy program before the expropriation. And so with this redundancy program adopted in after expropriation, that is reflected in documents post-dating the valuation date. And the only reason, hence, why this item entered into the tribunal's valuation was that the tribunal took the information post-dating the valuation date when it valued BDA gross liabilities. So this is, again, clear contradiction in the tribunal's reasoning. Information post-dating valuation date should not enter into the valuation, but that's exactly what the tribunal does there. Contradictory reasoning with the conversion fee. Again, I explained the issue yesterday. First, tribunal says, methodological point, conversion fee should be calculated using value of land from tax assessment. Then it took a completely different value. Now the question is not whether the value is correct or how Ms. Ilic calculated the value. The issue is that this is not tax assessment value. Serbia agrees. Serbia does not dispute that the tribunal did something else than it concluded should be done. Serbia tells you this is a mere computational error. Well, it's not. As you heard from Mr. Enway today, this is the exact example that took place in the Tidewater case. And that brings me to the last point, and that's the capital gains tax. So same as with respect to the discount discussed by Mr. Pekac, capital gains tax, again, one sentence for a reasoning. We take Mr. Kavan's number because it's objective and logical. What Serbia tells you, well, yes, that's correct, that was true. But, well, then, once again, this is not the point. The point is not whether that conclusion is correct or not. The point is that there is no reasoning for that conclusion. There is also no reasoning for why Dr. Hearn's approach was not reasonable or objective. Once again, Serbia told you yesterday, well, Mr. Hearn was instructed. Well, yes, Mr. Hearn calculated the capital gains tax based on certain instructions, but we respectfully submit that this is irrelevant for assessment of whether his approach was objective or logical or not. The fact that he followed certain methodology based on instruction does not answer that question. And with that, members of the committee, I thank you for your attention, and with Mr. President's leave, I'll pass the floor back to Mr. Pekac.
Thank you. I will address you in our last part of today's submission on the topic of jurisdiction and how the tribunal manifestly exceeded its powers by refusing to exercise jurisdiction over certain claims. For simplification, we refer to our grounds for annulment with respect to jurisdiction under that umbrella. But as we were rightly reminded by Professor Anaker's question yesterday, we also have a failure to state reasons type of claim with respect to one of the 4 jurisdictional decisions that we attack. So here, in answer to the question, we are here setting out the matrix of what we claim with respect to the 4 decisions. We claim manifest excess of power with respect to jurisdiction over the indirect shareholding under both the BIT and the ICSID Convention, and jurisdiction over the loans under, again, both the BIT and the ICSID Convention, and then failure to state reasons only with respect to jurisdiction over the loan under the ICSID Convention. So now first, with respect to the indirect shareholding, our points are the following. The existence of MDH Serbia's payment for the indirect shareholding was not disputed in the arbitration, and I showed you the slides yesterday. And this is because MDH Serbia's payment is ipso facto an indirect payment by Mr. Rand. This is the cornerstone of the protection of indirect investments. And therefore, with the existence of MDH Serbia's payment being undisputed, and the automatic attributability of that payment to its 100% owner, Mr. Rand, we submit the existence of Mr. Rand's contribution towards the acquisition of the indirect shareholding was also undisputed. What was disputed was the size. Now, how much he paid. We said he had paid 200,000 euros, and Serbia said, show me evidence for 200,000 euros being paid. But they didn't say, show me evidence of any payment. They knew that you cannot acquire shares on the market without paying for them. And I showed you the quote yesterday, where they say, actually it can be inferred that payment was made by MDH Serbia. We submit that this dispute about the size of the payment was irrelevant, first, because the tribunal does not really refer to it as a dispute over the size, but also because any contribution is sufficient to satisfy the Salini criterion. There's not a threshold which would say that you must have an investment of 1 million or you must have an investment of 10,000 to satisfy the contribution requirement. So this is one reason. Another independent reason why the tribunal committed a manifest excess of powers is that, as I said, the tribunal should have asked Mr. Rand about his contribution if the tribunal knew it was such a central piece of information for the tribunal's decision. And neither Serbia nor the tribunal did so at the hearing. Finally, the third independent reason I mentioned yesterday is the fact that the tribunal recognized several other additional contributions which were made during the lifetime of the investment, but for some reasons took that into account only when assessing the contribution criterion with respect to the beneficially owned shares, and did not take it into account when assessing the contribution criterion when assessing the indirect shareholding, even though the expenses were made at the time, some of them, when Mr. Rand owned both beneficial owner interest and the indirect shareholding. And Serbia's answer to it is that, this is a factual assessment. No, this is not a factual assessment. Factual assessment is whether or not contributions were made. These additional contributions, which I showed you yesterday. And once the tribunal concluded that these contributions were made, it's a question of methodology, of how they are allocated. There's nothing in the evaluation of evidence which would help. What the tribunal has to do is understand that if additional contributions are made, they count as contribution with respect to all other types of investment existing at the time. And the tribunal didn't do so. So now a few words on the loans. So here, yesterday it was somehow said that we did not argue that the carve-out from the carve-out, which I presented to you yesterday. It is true that we did not use these words, but we did lay out all the factual elements. And here, this is paragraph 452 from our rejoinder on jurisdiction. Serbia conveniently showed you yesterday only our second sentence. But what is important is also the first sentence. And we say that Serbia asserts that these payments cannot constitute an investment because they qualify as claim to money that arises solely from the extension of credit in connection with a commercial transaction such as trade financing. This is language taken from Article 1K of the BIT. So yes, we don't refer specifically to 1K of the BIT, but it's visible that this is where the language comes from. And then we say, however, Mr. Rand's payments for the replacement of BD Agro's herd did not constitute a trade financing, which refers to the case law interpreting 1K, because they cannot be separated from Mr. Rand's role as the beneficial owner. So again, we do not say, and therefore it satisfies the carve-out from the carve-out because this beneficial ownership satisfies Article 1H of the definition, which is expressly excluded. But all the factual elements are here. Then it was somehow suggested that the further expenditures made in furtherance of an investment are not an investment in themselves. And this is just, with all due respect, completely wrong. They are an investment in themselves if they give rise to a claim to money. And this is because of how compensation is calculated. And this is, if I extend a loan, or if I have a claim against, a claim to money against my investment, the value of such expenditures cannot be recovered in the equity value of the investment, so in my shareholding, because these are liabilities of the investment which are deducted from the equity value, and thus they must be recovered separately as my debt financing. That's why we have loans together with investments and claims to money together with investments in every definition of investment under all BITs. And my last point then relates to what the tribunal did with respect to the ICSID convention. So this is the one point where we also have the failure to state reasons in addition to a manifest access of powers. The problem there is that the tribunal failed to state reasons because it did not explain what duration would be required. And without setting the threshold, the tribunal cannot say why the loans did not have the required duration. And then the tribunal also manifestly exceeded its powers because it incorrectly rejected jurisdiction over an asset which clearly satisfies both the definition of an investment in the BIT and the Salini test, if applicable. And with that, I thank you, members of the committee, for your attention. That concludes our rebuttal.
Thank you for keeping time. Yeah, perfect. 11 o'clock. We'll take a break for 15 minutes and resume in 15 minutes time for Serbia to make its closing presentation. Thank you. And also that we propose to parties that following your presentation, maybe we'll have a little discussion. If we have questions, we'll just toss it up. And rather than we take time out for 1 hour for lunch and then come back, so that we can, if you have no objection, we propose to work through all the way and then adjourn, and then you go for lunch. We may have a late lunch.
We agree.
But I think in Spanish terms, it probably is still early lunch. Yeah. So if that's okay, we will work through. And of course, subject to Mr. Travers. Okay. Very well. Dr. Joy. Oh, okay, Ms. Khan.
Thank you. Members of the committee, yesterday applicant attempted to describe what he calls the background of the proceedings. And this part of the applicant's presentation was both irrelevant and unnecessary. However, since it does not resemble the truth, I will firstly say something about financial conditions of BD Agro prior termination of the privatization agreement on 21st October 2015. And this date is later, as we all know, accepted as valuation date by both parties and consequently the tribunal in the arbitration proceeding. So applicant argued that before privatization, BD Agro was in catastrophic condition and required investment, and that after the alleged investment of the claimants, they transformed BD Agro into a state-of-the-art farm. However, the truth is very different, and what happened is that after privatization, BD Agro was also in a catastrophic condition, and that is not speculation, that is proved by extensive documentary evidence in the arbitration proceeding, and it is also explained and referred to in our counter memorial on annulment. To cut the long story short, the hallmark example of BD Agro's mismanagement after privatization is the permanent blockage of BD Agro accounts for more than 2 years before privatization agreement was terminated. In other words, BD Agro was de facto bankrupt years before bankruptcy proceedings was finally initiated in 2016. And also, it is worth noting that this was duly noted in the award in paragraph 680. So you can see that part of the award on the screen. I will now continue with addressing the committee's question related to where the dividing line is between material that is post-valuation dated and pre-valuation dated. So first, it is undisputed that both parties accepted 21st October 2015 to be the valuation date, and this was acknowledged also in the award in paragraph 682. Then in paragraph 693, the tribunal stated that it is well accepted that information used for valuation should originate on or before the valuation date. In other words, information that originated before or on 21st October 2015 can be used for valuation of BD Agro assets, and information that originated after the date should not. And parties' experts were of the same opinion, and you can see that from their expert reports. And it is, I think, not even disputable. So what the applicant turned into disputable question in this annulment proceeding is whether such information could have been looked for in the documents created after the valuation date. And of course, the obvious answer is in affirmative, and that was also noted yesterday by Mr. Ohishin. And we have also that quote on the screen. So therefore, when stating that information used for valuation should originate on or before the valuation date, and when thereafter accepting valuations that relied on second Confinex report and 2015 financial statements, the tribunal actually did not contradict itself. On the contrary, what the tribunal did, it followed what both parties' experts deemed to be the correct approach, and that is to use these post-valuation date documents, indeed, but as a source of pre-valuation date information. And applicant, of course, can now criticize tribunals for accepting the reliance on these documents, but while doing so, the applicant forgot that his own expert, Dr. Hen, regarded these documents as the relevant source of the information for valuation of BD Agro assets on 21st October 2015. And you can see that clearly from Dr. Kerr's first report, for example, from paragraphs 47 and 159, and then again from paragraph 79 and footnote 66 of his first report. So in these paragraphs, Dr. Hen, claimant's expert, explained why reliance on these documents is more than justified. Both Confinex reports, both of them, first and the second Confinex report, and also 2015 financial statements. So in other words, we can conclude that Dr. Hen shared actually Mr. Coven's and the tribunal's understanding that second Confinex report and 2015 financial statements are a proper source of information predating the valuation date. And you will see, actually, he explained why is that so. So he noted the valuation in the two Confinex reports, one of which uses 31st December 2014 as a valuation date, and the second which uses 31st December 2015 as a valuation date, are not substantially different. And then he observed the same with regard to 2014 and 2015 financial statements, that the values reported therein are also not significantly different. So therefore, I now will conclude with this, applicants' critique of tribunal's reliance on these documents is rebutted by applicants' own experts. And I will now address applicants' arguments related to total estimated liabilities. And during his opening statement, the applicant argued that the amount of the total estimated liabilities calculated by Mr. Kovan in his second report and later adopted by the tribunal includes deferred tax liabilities, and then they again repeated this morning. However, they disregarded respondents' comment that even if true, that cannot be raised in the annulment proceedings, because after Mr. Kovan's second report, in which he stated that he accepted Dr. Herr's double counting observations and that he has corrected his calculation, Dr. Herr, but not only Dr. Herr, but also claimants, raised no objections with regard to Mr. Kovan's corrected calculation. What we heard today, and that is on the slide 83 of today's applicant's presentation, is that Dr. Hen actually, let me just read that, sorry, just for a second. Sorry for wasting everyone's time. Okay, so on the slide 83, what they said is that Dr. Herr did not comment on this issue in his third report because his report was limited in scope to certain new assertions raised in Serbia's rejoinder and accompanying documents. Limited, but limited by who? Well, by claimants. As you will see in Dr. Herr's third report in paras 106 and 107, Dr. Herr explicitly notes that he is instructed to address certain issues from Mr. Kovan's second report and to disregard some other issues from Mr. Kovan's second report. One of these issues was double counting. And again, don't forget that after these experts' reports, we of course had a hearing, and nobody questioned at the hearing Mr. Kovan about alleged double counting. So why would the tribunal question that? I'll move on conversion fee. Yesterday, applicant stated that the tribunal said, I quote, for this calculation, we relied on the value of the land stated in tax assessment. This is clear misrepresentation, and what the tribunal said is, we can see on the screen, that is para 699.2 of the award. So as you can see, the tribunal did not say what applicant assert, as that would mean that the tribunal wanted to provide its own calculation by using the value of the land stated in the tax assessment, but that is not what the tribunal intended. Instead, as it is clearly noted by the tribunal first accepted Ms. Illich's explanation that the fee must be calculated on the basis of previous year's tax assessment. And then the tribunal noted that Ms. Illich calculated conversion fee, which was then used by Mr. Kovan. And third, having in mind that claimants did not dispute that calculation, the tribunal adopted the conversion fee used by the respondent's experts. So again, claimants did not dispute the calculation provided by one of the experts. Therefore, the tribunal had the right to accept that calculation as the correct one without questioning it. And of course, applicant's misrepresentation of tribunal's reasoning is for purpose. He needed to misrepresent tribunal's reasons in order to be able to refer to Tidewater case. Why? Because there the tribunal explicitly rejected certain valuation criterion as unreasonable and then used the very same criterion in its own calculation. So unlike in that case, in the present case, the tribunal did not use valuation criterion it previously rejected, nor it performed its own calculation, but instead accepted Ms. Silić's explanation that the calculation should be based on certain method, and then, in the absence of contrary indications provided by claimants, accepted Ms. Silić's calculation, for which she stated was performed using that method. So these are totally different factual background. Related to court proceedings liabilities, applicant failed to rebut Serbia's argument that when saying item, the tribunal didn't mean to say we accept the amount from the financial statements, but that what the tribunal said is that we accept the category of the court liabilities. We accept that the category of the court liability should be included in the assessment. Instead, what the applicant did during the opening, but also today, is to explain the obvious, and that is that the amount calculated by Mr. Kovan and accepted by the tribunal and the amount from 2015 financial statements are not the same amount, but that is not in dispute at all. We agree. These are different amounts. However, what the applicant fails to note is that in the footnote 584 of the award, the tribunal made a reference to Mr. Kovan's report to paras 217 until 220. And in these paras, Mr. Kovan explained why these numbers are not the same. So actually, Mr. Kovan provided explanation. So this reference to Mr. Kovan's explanation, why these numbers? Yes, please.
Sorry, just to clarify, in the arbitration, was there a dispute between the parties' experts whether this category of liabilities should be included in BDAGRO's liabilities, or was it only about the size of the liability?
As I recall, it was both. But I will have to check that. I will come with that later today. Thank you.
Thank you.
One sentence about these court proceedings, that the reference to Mr. Kovan's explanation why his number differs from the financial statements is another confirmation that the tribunal did not want to accept the amount from financial statements. I will now move on to capital gains tax. So, applicant asserted that the tribunal did not explain why it believed that Dr. Hearn's calculation was not objective and logical. The answer is rather obvious, and in fact stated by the tribunal in the award, and that is Dr. Hearn did not provide any arguments as to why he used deferred tax liabilities from BDAGRO's financial statement as a proxy for calculating capital gain tax, except that he has done that based on claimant's instructions. Mr. Kovan, on the other hand, presented his own estimate and explanation of his approach. And in the footnote 585 and 586 of the award, the tribunal referred to both expert opinions, where these facts are stated by the experts, and then concluded that Mr. Kovan's calculation is objective and logical. And indeed, the analysis of an expert must be deemed as more objective than the instruction given by one of the parties to the arbitration proceedings. And finally, I will say something about redundancy payments. So, as to the tribunal's findings related to the mandatory nature of the redundancy payments, I would just like to note that applicant has completely ignored respondent argument that in the award the tribunal referred to the Annex 1 of the privatization agreement merely as in any event consideration, and what in any event would mean in the award, if not that is only an additional argument but not the crucial. And applicant also failed to comment on the fact that the tribunal has supported its conclusion that redundancy payments are mandatory by quoting the financial statements in the footnote 588, and that Mr. Covan referred to labor law in order and to PricewaterhouseCoopers report in order to support his conclusion that redundancy payments are mandatory. And finally, today applicant mentioned pre-pack reorganization plan and stated again, this is not new argument, they already made that argument, that reorganization plan did not include redundancy payments, which is not correct. So this is pre-pack reorganization plan from March 2015. It is Exhibit CE 101, and on page 72 and 168, you can see that that document included redundancy payments as mandatory. And for the sake of completeness, I forgot to say something about Banca Intesa claim when I speak about total estimated liabilities. I would just like to say a few words about what we heard today from applicant. I already addressed that question yesterday, and I explained that this claim was the subject of the court proceeding that ended by the final court decision before valuation date, and that Mr. Cover has used only information from that decision for its calculation. Applicant now argues today again that all these documents post-date evaluation date related to Banca Intesa claim, but information actually predates the evaluation date, but not only information. You will see that also the documents, the awards, predates the evaluation date. And it is not true that Banca Intesa did not claim that claim before valuation date. Court proceedings related to that claim ended before valuation date. Thank you very much. With this, I'm finished with my opening, with my rebuttal, and now with my colleague, Mr. Jeric.
Before you do that, you talk about the, can you show me the document that talks about Mr. Hearn's instructions were limited by, report was limited by the instructions of the claimant?
Yes, sure.
Can you just show me that? I know there's a footnote.
Ah, okay. Oh, yeah, sure.
So I just
Just a
know
second.
what
So it is
exactly
third-
were the instructions.
Yes, sure.
Yeah.
It is third Harris report,
Yeah, but how do I get it out? Yeah.
of course, and we will show you the paragraphs just a second. So you see paragraph 106 and 107. Sorry, paragraphs 106 and 107 of Dr. Hans' report. So in 107 he said, while I disagree with several other aspects of Mr. Kovacs' second report, I have been instructed to not respond to these issues. Second report. Third. No, piše second. Yes, I see now that actually it says on the document it is, no, response to new issues to Mr. Kovacs' second report is good. And after this instruction, and after failing to address that question at the hearing, I think the double counting argument after Mr. Commons' second report does not stand anymore.
So
7 is what you're talking about.
Yes, from paragraph 106, we can see what was the topics that Dr. Khem was instructed by claimants to address. And then in 107, he says, well, I do not address, for example, double counting issue because I was instructed not to do so.
Okay, thank you.
Thank you, Mr. President, members of the committee. I will have to be fast because before the claimant's rebuttal, I thought we have ample time, but there is so much to cover now in response to what they have said. I will start with Dr. Anaker's question and would like to make a few observations first. It's about our understanding of the term reliance that is referred to in this question, and the reliance as related to the case itself, to the original case itself. And our understanding is that it has at least two somewhat different meanings. Land valuations that experts prepared were based on certain prices with very specific sources, and we could call them primary sources. So, for example, Mrs. Ilic relied on asking prices, and that was her primary and only source. Now, for the two Dobanovci transactions, she disregarded them, considered them and disregarded them. So she did not rely on them. Likewise, Mr. Grzesiek relied on the Batajnica transactions. He discussed others, but he did not rely on them at all. Now, Dr. Hearn also had certain primary sources. For his upper bound price was Mr. Murgood's valuation. For his lower bound price, it was the tax authority's valuation. And you can see that at paragraph 89 on his report. In addition to those, he uses what we can call secondary sources. And for example, his secondary sources for upper bound price were Pazova and Batajnica transactions. Batajnica transactions do not appear here because they were brought to the case later on, but he also relied them as a confirmation of his original valuation. So, but I would like to underline that Dr. Hearn's valuation itself was not based on these secondary sources. It was also based only on the primary sources, while he used the secondary sources only as broad confirmations, as he says, of the price taken from the original source. So in that sense, today's presentation provided by applicant in response to Dr. Anaker's question was somewhat misleading because they bundle up everything together and show that the experts relied on many different sources, whilst in reality they relied on one source to calculate the valuation. And on other sources, they just used them as a confirmation of their own position, but never made the calculation itself. And that's here I talk about Dr. Hearn, who is using this technique. In addition, before going to the table of the references, I would also like to say that as regards Pazova transaction, a little note, applicant said that Dr. Hearn relied on them, and then as a support, he crossed part of our presentation containing his own words at the original hearing, where he said, would you agree with me that he did not use, that Dr. Hearn did not use the 51 square meter as a comparable? That's a Pazova transaction. So, now going to the question of assessment of evidence. Our submission is that when the tribunal rejected the primary source for the valuation, for example, Batajnica transactions in case of Dr. Grzesiek, or Murgood's valuation in case of Dr. Hearn. When the tribunal did so, it was not required to deal specifically with the secondary sources because no valuation and no claims were made on the basis of these secondary sources. As noted by the committee in Ecuador, Occidental v. Ecuador, when there is no claim or specific request for relief, as they say, there is no need to give reasons. So I think this is relevant jurisprudence in this regard. So the tribunal was not required to deal separately and independently with the Pazova transaction, but in its transaction as well as with the Dobanovci transactions, once the primary sources of Dr. Hearn's and Mr. Grzezic's valuation were rejected. Let's assume that it was required, for the sake of argument, it was required to deal with them. Probably the award would be the awards would be much, much longer and more complex and much more difficult to draft than is usually the case. Now, as instructed, we provide a table of references where the parties and experts relied on the Pazova transactions, and this table does not contain all possible references to these sources, but only when they were relied upon the parties, specifically claimant or experts, in their land valuation, and when they were expressly and directly mentioned as such. So we were sort of a little bit stricter in methodology.
Just for my education.
Sure.
X meaning
Meaning
used or not
not
used?
mentioned.
Not mentioned.
Not
Okay.
mentioned, yes. And we also mentioned one exhibit that is not in the file, and it's indicated it's not in the file. That's first reported by Mr. Cohen, who initially relied on the second Confinex valuation, but eventually relied on Mrs. Illich's valuation of the land. Now, moving on to asking prices as a part of an international standard of valuation. Yesterday, we discussed that. Applicant said that this was not, the use of this source was not in accordance with international standards. And we had provided the references already yesterday to Mrs. Illich and Mr. Grzesic. And I today would like to show you the relevant standard reprinted from Mrs. Illich's report, which expressly mentions asking prices. And also on the next slide, you can see that claimants in their post-hearing brief also assumed and accepted that international standards included the asking prices as a source. Now, moving on to the 30% discount. Now, what Mrs. Illich suggested were the reasons for the discount and what the tribunal accepted in the award. That is subject of considerable controversy. And let me walk you through the award and the references. Now, if you the 30% discount is discussed in paragraph 695, and in the first sentence under 3, you say that the tribunal describes how Mrs. Illich applied a further 30% discount to account for the larger size of the BD Agro's land as compared to the comparators. And here, I submit to you that the tribunal did not refer to the construction land, to which it refers with a capital C and capital L. It refers only to the BD Agro's land. And this is additionally confirmed by footnote to the BD Agro's land. This is footnote 566, which refers to Mrs. Illich's valuation of Ugrinovci agricultural land, to her evaluation of the Bečmen agricultural land and Novi Bečej construction land, and obviously not to her evaluation of the construction land or zones ABC land, construction land with a capital C. And only in the continuation of this first sentence, the tribunal also mentioned that the 30% discount was also based on existence of other factors, quote, such as existence of infrastructure and access road, end of quote. And here, in footnote 567, it referred to Mrs. Illich's presentation at the hearing, which concerned only the construction land. And let me go to the other part of the hearing, where you can see that this was obviously also understanding of claimants while crossing Mrs. Illich, because they cross-examined her why she based her 30% discount on the construction land with capital C and L only on the lack of infrastructure and not on size. And then in the cross, she confirmed that the discount was on the construction land was based on the former factor only. Now, it is true that Mrs. Illich mentioned in her first report that the 30% discount was based on the differences in size between the median size of comparative parcels and the median size of BD Agro construction land parcels. That is page 115 of her first report. And there, at page 115, unlike as in other cases in her report, where the difference in size was in favor of comparators, meaning they were smaller than the land valued. In case of the construction land, its parcels were smaller in size to the comparator, so it was the other way around. And applicant on this basis argues that this should have therefore attracted premium and not a discount on the construction land. However, applicant once again ignores the fact that Mrs. Illich conclusively stated at the hearing that the 30% discount in case of the construction land was based on differences in infrastructure, not on size. And unlike the applicant, the award does not ignore this, because when it moves to paragraph 697, discussing the size first, the tribunal noted that the 30% discount was to account to a larger size of the BD Agro's land and refer to Mrs. Illich's valuation of the land other than the construction land in footnote 566. But in the next paragraph, the tribunal referred to Mrs. Illich's valuation of the construction land only to note that this land and comparators were of different size. You can see that on the screen, I believe. Yes, first sentence, paragraph 697, and the footnote. Footnote 569 there referred again to Mrs. Illich's report, where she stated that she applied the discount and provided numbers showing that the construction land parcels median size is smaller than comparators, and that this was done on the basis of her experience. So the tribunal noted, actually, when describing the award and in the footnotes, that the tribunal shows how Mrs. Illich provided different discounts on the basis of the size. But the tribunal does not engage with these discounts because eventually it considers the size irrelevant. The size can go both ways, I would say. It only stated that, quote, size does matter and nothing else. It did not take the side whether the bigger or smaller size matters. It stated, in effect, that BD Agro could either concentrate or divide its land, whichever would attract the higher price. And I believe that this was also discussed by the parties exactly in these words. In paragraph 697, then, the analysis moved to the factor that the tribunal thought should bring the discount, and that is the construction land as undeveloped land and the differences in infrastructure. And here, the tribunal, you will remember, referred to the firm position of Mrs. Illich and concluded that her testimony that differences in infrastructure justify the discount was not seriously rebutted. You don't have it on the screen, but you have seen it yesterday a lot. Therefore, all this clearly indicates that as regards the construction land with the capital C and L, the tribunal accepted the 30% discount on the basis of the differences in infrastructure, as Mrs. Illich suggested at the hearing. Now, maybe Mrs. Illich can be criticized for not being clear enough or even for changing her mind about the source of the 30% discount for the construction land. But this is a question of assessment of evidence and the credibility of the witness, and obviously it is not appropriate for annulment proceedings. And by the way, as we noted in our post-hearing brief in the original arbitration, claimants' experts as well were contradictory about the impact of the size of the land on its price. Mr. Hearn thought that a larger size pushed the price down, and Mr. Grzesiek thought, no, this is great, the larger the better, so to say. And now moving on to conclude, when the tribunal decided that size does matter, but can be overcome as a price factor, it did not need to decrease the size of the discount, because the 30% discount in case of the construction land with capital C and with capital L was based on differences in infrastructure only. And I hope this also answers your question, Mr. President. Now, shortly about the magnitude of the discount, Mr. Peckers today said, well, 0 is also a number, so there is a range. Well, claimants could have, but didn't say what he said today about the methodology and about the, of counting the magnitude and on what it might depend or might not depend. They were completely silent. They did not even consider the situation where some discount is accepted by the tribunal. So therefore, they did not provide any indication about the size of the discount. So what he said today, if he said it then, might have been an argument and might have given the tribunal something to work with. However, they were silent, and the tribunal had only Mrs. Illich's number to work with, and the tribunal found it reasonable. So we submit this was a sufficient reasoning. Now, yesterday, one of the contradictions mentioned by claimant was that the tribunal applied the 30% discount also on BD Agro's other construction land in Dobanovci, which had access to infrastructure. That is the tiny farm, so to say, because it is about 2% of the construction land as a whole. And so it is basically non-issue. However, what is more important in the present context is not this factual assessment, whether it's big, small, with infrastructure or without, because this is not the subject of the present proceeding. The most important thing is that the claimants never raised the issue of why the 30% discount is applied to this land. And they could have done it in the original arbitration. They didn't. They had everything in front of themselves, but they were silent again. And they cannot now raise this issue. In other words, they never criticized Mrs. Illich for that. Now, I would like to now discuss certain contradictions. One that were invoked by applicant. One is about ignoring the second Confinex valuation in the valuing of BD Agro's land. Now, and at the same time, using the same valuation as evidence for the value of BD Agro's liabilities. And that's their opening statement, slides 113 to 115. Now, there is no rule prohibiting that the tribunal may use one document in one context and then not using it in another wholly different context. The tribunal does not need necessarily to explain why it is using it here or not using it there. The tribunal has to explain why is it using it in that particular case. And the tribunal explained in our submission or provided sufficient inferences why it used Mr. Cohen's evaluation of liabilities, which was based on the second Confinex report. And also why we explain why it did not need to address at all the second Confinex valuation in the context of the land valuation. Now, today, in this context, for some reason, claimant provided an argument, a table, stating that they they provided a table where also Confinex second valuation was listed, and that is for them evidence of their referring to Confinex land valuation itself. But mind you, the table with the different valuation was the table with total valuations of the land, and its first item says claimants, so how claimants value the land, and then some items say second Confinex valuation. So it was only provided as a matter of analogy or a matter of comprehensiveness, and not in relying on the second Confinex valuation as a total number in the valuation, and especially not as a number in specific valuation of the construction land. Now, 6 principles. They insist on the 6 principles. Now, the problem with the 6 principles is not only that they are sometimes imprecise or outright manipulative summarization of what the tribunal said, and I will come back to that. The problem is also in methodology. So it's simply not the same kind of statement to say that the tribunal accepted that only evidence on or before the valuation date should be used for valuation, or to say that the tribunal somewhere stated that the 30% discount should be based on the size of the land or existence of infrastructure. This is not simply methodologically, this is not the same principle. One is a fundamental principle used in evaluation. Another is something which we extract from the factual records and from what the tribunal commented about that factual record. And obviously, if we do this latter thing, then we come we face the problem that there are different assessments of the factual record. So it's very hard to argue about the valuation date, whether it's this date or that date, and because that's in the international standards. It's a fundamental rule. But as you have seen, we have argued a lot about whether the tribunal provided a principle or finding that the discount should be based on the size of the land. And the principle was formulated as principle number 6. Smaller plots are more valuable than the larger plots. That's slide 12 today. However, the tribunal itself or himself is contradictory about that, because at slide 58, the tribunal says that actually, the applicant says that actually the tribunal accepted that the size does not matter. So which is which? You see here, the tribunal disagreed with any discount based on the size of the construction land. So this statement goes directly against principle number 6. So there is a fundamental problem of methodology, and also the problem of claimants summarizing the fact in their own favor and not objectively. Now, I'm now moving on to, sorry, I'm not sure where we are now. Okay. On some of the 6 principles, and you will see, and I will just cut it short now, that all these principles depend on a factual assessment, or application of these principles depends on the factual assessment. For example, second principle, asking prices have the lowest evidentiary value, and the valuation should not rely on asking prices with no corresponding information about dates and sources. And then we immediately go into discussion whether there are dates and sources, and what kind of source is relevant, and what kind of source is not relevant, etc., etc. So this is at all not an issue for these proceedings. And applicant would like you to go into these issues. So in order to to find a contradiction between so-called principles and the findings, you will need to go into the assessment of facts. And my colleague, Professor Jundic, will say a couple of words more about that. Again, first principle, the evaluation should be based on actual comparable transactions. Actual comparable transactions. The question again is, what is is it comparable, is it not? Whether is it in the residential area or here or there, you have heard a lot about it. It entails factual assessment. Now, I don't know how much time do we have left, which is 18 minutes. 18. Oh, I think yeah, that's plenty. I'm finishing and my colleague is taking over. I would just like to say a few words about, to comment on today's rebuttals by applicant. And primarily about the two transactions in Dobanovci. Now, Mr. Pecker again insists that Mrs. Illich accepted at the hearing that the two transactions were actually did not concern the land in urbanized area, and that actually she gave up on the ratio of her decision to disregard them. We disagree, and we have written a lot about it. It's in the submissions, for example, counter memorial at paragraph 119 to 132. We submit that Mrs. Illich never retracted and never accepted these two transactions as comparable. And again, this is a factual issue. Now, second question, and that's a question also for you, is why Dr. Hearn did not provide evaluation based on these two transactions, which were known to him at the time he wrote his third report. Now, the answer is very simple. He was instructed not to do so by claimants. That is at paragraph 10 of his third report. Now, next question, also related to that and to the support that might or could have been provided to claimants' valuation in the arbitration. Mr. Grzesik, another claimants expert, based his valuation on the Batajnica transactions. Again, the question is why Dr. Hearn did not accept what Mr. Grzesik provided as a number, as a price. He stayed with his own valuation. So you see there that claimants experts provided two different valuations. They also had somewhat contradictory approaches. And most importantly, I think that claimants basically figure out that they could use the two Batajnica transactions only at the hearing itself. And they did. And they were rebutted and their arguments were not accepted. But that's a different thing. Now, we also have the question of implicit reasoning. That's a more like a general legal question. You have heard today many times applicants saying, well, let them point to the award. Let them point to the award. Which paragraph, etc., etc. Now, they have not at all engaged into our argument from yesterday and from our previous written submission about implicit reasoning, about inferences in the award. And I think that the case law is quite clear. We have provided yesterday at slide 49 of our opening presentation case law, and you are well aware of this case law. And I would just like to underline that the claimants decided not to engage with this case law, not to rebut this position, but continue to insist that the award must expressly provide all the necessary reasons. And I submit to you this is basically impossible. And finally, just one sentence, whether Dr. Hearn relied on asset-based methodology. It was mentioned a little bit yesterday and it was mentioned today. Yes, Dr. Hearn provided evaluation based on adjusted asset-based methodology. However, that was only his alternative valuation. His primary valuation was DCF, and he insisted on DCF, as you can see at his first report at paragraph 156. And with this, I pass the floor to my colleague, Professor Đunđić.
So, members of the committee, I will first try to answer Dr. Anaker's question about the standard for contradictory reasoning. So, as we understand it, there are two aspects of the standard today that can be considered as undisputed. First, the contradiction in reasoning must be genuine and not construed. So this is evident, for example, from Tidewater v. Venezuela, Teco v. Guatemala, Continental Casualty v. Argentina. A genuine contradiction exists when conflicting reasons completely cancel each other out, and as a result, the reader is unable to understand what motivated the tribunal in reaching the decision. This aspect of the standard was summarized in Tenaris versus Venezuela 1 decision. The last sentence of this paragraph is particularly important. If the tribunal reasoning can be followed, then reasons may not be genuinely deemed contradictory. Second, the threshold for contradictory reasoning is exceptionally high. A contradictory reasoning exists only when contradictions cause the award of being incapable of standing together on any reasonable reading of the decision. So this was, for instance, accepted recently in infrastructure services versus Spain. All of these, just to say, all of these awards are on the record. And also Soles versus Spain, where the committee stated that the genuine contradiction exists when the award is incapable of standing together on any reasonable reading of the decision, and referred as such approach as consistent with the committee's limited role in annulment proceeding. Now, with regard in particular to your question about the relationship between the contradictory reasoning and contradictory assessment of evidence, the most important distinction was already touched upon by the opposing counsel. The main difference between two types of errors, so to speak, is their position in the annulment proceeding. While contradictory reasoning can be, in exceptional circumstances, can be a reason for annulment, the contradiction in assessment of evidence is basically an incorrect assessment of evidence. And incorrect assessment of evidence is not, as my colleague said, is not a reason for appeal. It's not a reason for annulment. The fact was explained in Tenaris versus Venezuela, but since this issue is undisputed, we can move on. The difference between the two is also evident from understanding that the committee should not annul the award based on Article 52(1)(e) because it deems that the reasoning was incorrect. So this is the understanding that goes back all the way to the Maine versus Guinea and Vena versus Egypt cases. The most relevant statement about the relationship between contradictory reasoning and errors in evaluating evidence was given by the committee in Karatube 1 case. That is paragraph 102. The committee explains the meaning of contradictory and frivolous reasoning and states that contradictory reasons cancel each other and will not be enable the reader to understand the tribunal's motives. Frivolous reasons are those manifestly irrelevant and knowingly so to the tribunal. But this is the highlighted part of the reasoning is the most relevant one. But an examination of the reasons presented by a tribunal cannot be transformed into a re-examination of the correctness of the factual and legal premises on which the award is based. Now, we submit, members of the committee, that the reasoning is not contradictory if an informed reader can understand the motivation behind the award, even when the tribunal's reasoning was influenced by an error in valuation of evidence or in an assessment of facts. What I'm trying to submit basically is the following. If contradiction arises only after an applicant convinces the committee that the tribunal committed an error, and if the contradiction, possible contradiction, is a result of a wrong valuation of evidence, then there is no annulment. This is because the annulment committee cannot go, as it is universally accepted, in re-evaluation of evidence. Otherwise, the committee's task would turn into what the Carrot Tube 1 committee calls re-examination of the correctness of factual and legal premises on which the award is based, which is just another way of saying that the committee would be a court of appeal. Now, there are also certain points raised yesterday and today by the opposing counsel with regard to the manifest excess of powers that I would like to address in constraints with the timing. The first point relates to the indirect shareholding. Yesterday, the applicant argued that Serbia accepted that MDH Serbia paid for the 3.9% indirect shareholding in BD Agro, and that the respondent disputed only the amount paid for the shares and not the payments that took place. The assertion is based on one sentence from respondent's rejoinder of 24 January 2020, and it is incorrect. Respondent argued that Mr. Rand failed to prove his contribution and merely raised the possibility that the indirect shareholding was paid for not by Mr. Rand but his Serbian company. However, respondent clearly stated, and this is evident from the slide that was presented again today by applicant, that no evidence of such payment has ever been submitted. So Serbia clearly stated that no evidence of such payment has ever been submitted. This is hardly an admission that the payment was made. Respondent's position in no uncertain terms was repeated in its first post-hearing brief of 28 September 2021. So due to technical issues, I have no possibility to present you the slide with this paragraph of Serbia post-hearing brief, but I kindly ask you to consult the paragraph 158 of the post-hearing brief, first Serbia's post-hearing brief of 28 September 2029. I will just read the relevant paragraph. Fourth, some of claimants' alleged expenditures still remain undocumented and unproven. This is, for example, the case with the remainder of the purchase price after the Serbia agreement was concluded, or with the price of 200,000 euros allegedly paid for MDH Serbia's 3.9 stock in BD Agro. So this is categorically disputing that the payment was made. Now, before this date...
Sorry, could you give us the paragraph number?
It is 158. Now, before this date, before 28 September 2021, claimant had 3.5 years to submit necessary evidence and to prove contribution. And please bear in mind that this was the first post-hearing brief out of 2 rounds of post-hearing brief that parties could have submitted during the arbitration. So even after that, claimants could have offered to submit necessary evidence. or at least they could have protested about Serbia's apparent sudden change of heart. But they never did anything of this. So, finally, the sole judge of admissibility and probative value of evidence is not and was not the respondent, but it was the tribunal. So, claimants essentially failed to convince the tribunal that Mr. Rand made necessary contribution, and that should be the end of the matter. The second issue concerns the applicant's claim that the payments for the benefit of BD Agro fulfilled the requirement of duration under the ICSID Convention. Now, the applicant argues that the payments lasted for 7 years until the valuation date and a decade before the arbitration. This was at least presented yesterday. Now, this is a fallacy. It might be even the clever one, but it is fallacy nevertheless. The duration of a transaction is not calculated by the amount of time in which claims to money created by that transaction remains unsettled. If that would be the case, every sales contract would meet the duration requirement simply because a buyer decides not to pay purchasing price for 7 years or for a decade. The only thing relevant for duration requirement was how long the payments themselves lasted, and for the alleged lack of explanation offered by the tribunal. No one can seriously argue that the transfer of money from one banking account to the other lasts a decade. The explanation is implied in the fact that the tribunal characterized Mr. Rand's payments as simple payments and not loans, and from the character of the transaction immediately follows that the transaction did not meet the requirement. Now, the opposing counsel today raised the issue of Serbia not contesting the argument that the tribunal should have inquired with Mr. Rand about his contribution during the arbitral proceeding. There is a good reason for our omittance to deal with this argument, because we believe that there is no need to explain to distinguished and experienced arbitrators the rule that claimant in international arbitration must marshal necessary evidence to prove its factual assertions. So this is the rule that is well known, that does not need explaining, regardless of the fact whether the issue was raised by respondent or even by the tribunal. Finally, today we have heard that claimants have, according to the applicant, made an argument during the arbitration about the so-called carve-out of the carve-out provision, that is last sentence of Article 1L of the BIT. I will try to do the same thing that the opposing counsel did on several times. I would like to ask you to go through the record and try to find any discussion about the meaning and scope of the carve-out provision in claimant's submission. There is nothing about that. So this concludes respondent's rebuttal. Thank you.
Thank you very much. Yeah. You have any questions? No? Any further questions? No?
I'm sorry, Mr. President, if I
Yes.
may to use 20 seconds
Yes.
just to respond to the question related to court
Of course.
proceedings liabilities. The parties disagreed about whether this category of liabilities should be included, and you can see that from Mr. Kovan's third report in paras 731 and 732, and also, sorry, that is second report of Kovan's. Second report of Kovan, 731 and 732, and third report of Mr. Kovan, table in para 448, and you will see all items where two experts disagreed.
Thank you.
Thank you.
The only question I have relating to the 30% discount is that the tribunal accepted Ms. Illick's proposal that 30% is applied to all the land, not just the construction land, but it's also the agricultural land and all the land. Am I correct? I'm actually looking at Illick's first report, and she seems to have applied 30% to everything.
I think I can give you an answer, but I'd like to check.
Okay.
I think it's a little bit out of the scope of what we were focused on in the last 48 hours.
Yeah. If there's nothing else, then last direction for you is to ask parties, what about the submission of costs rising out of this annulment proceedings? Have you discussed with each other? How long do you need to make that submission? I'm sure you can do that quite fast, right?
We have not discussed on our end. The only thing we need is a close of the month, obviously, for our accounting systems to be able to process the bills. So I would say mid-July.
Mid-July is fine, yeah. Is that okay?
Mid-July is fine, yes.
Okay, that sounds good, yeah. So we just arrange a date in which you both exchange and submit it to us. Don't forget all documents, please upload it to the box so that we can all have all access instead of trying to download from different sources, okay? And notify, of course, the Secretariat, the ICSID, so that we'll be informed and we'll download them. Yeah, anything else from you? Anything else from you? No? Anything from you? No? Which brings us to a very pleasant time to thank everybody for your presentation, and we'll do our best to see what we can do to come out with a decision on the application. And that will be the end. On behalf of the committee, we thank you for your attendance, your presentation, and for being patient with us as well, for asking questions, probing you. Thank Trevor and his team and the technical staff here in this wonderful place to host us in this hearing. Thank you very much, and safe voyage, safe travel back to wherever you have come from. Thank you very much.
Thank you very much.
Thank you.